Hi, my name is Liza Odom. I'm a student at Southeastern Oklahoma State University. I am creating a policy training manual on least restrictive environment. I felt like in this new day and age, I should format it as a website, and so that's exactly what I did. So let's go ahead and get started. This is the home page of the website. It's for least restrictive environment. It is so much more than a place, so much more than a place. And so I hope that this website is geared at letting you know what you can do to ensure that LRE is being followed in the classroom and is being provided to each individual special education student. It is a guiding principle. It is directly in the text of IDEA. Here are several links for us to follow. We should start at the beginning, I guess, where it's from. So let's go there. It's a powerful term in special education. It is shortened to LRE, so that's how I'll refer to it the rest of this time. It has been the source of a lot of questions regarding criminal or civil court cases and so the Supreme Court. Earlier in the semester, we talked about the history of special education law, and so I included that video for those who are not very familiar with the history of it. It was started in the Act of 1975, Public Law 42, 94-142 to be specific, of 1975. It provided guidance to states and allowing students with disabilities to have access to public education and providing financial assistance to states. And so it was the first national act to address the growing injustices children with disabilities were facing in the United States. And so years later, a more robust act called the Individuals with Disabilities Education Act came out, and it had least restrictive environment, and it goes hand in hand with the free and appropriate public education. So the idea of LRE is pretty easily spelled out in the law, and so here it is. To the maximum extent appropriate, children with disabilities, including children in public or private institutions or other care facilities, are educated with children who are non-disabled. So all students should be educated in the same buildings. Special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only if the nature of or severity of the disability is such that education in regular classes with the use of supplementary aids and services cannot be achieved satisfactorily. So I think a lot of when we talk about the laws and the cases that come after IDEA came out has a lot to do with this clause. When do we remove? When do we say that the use of supplementary aids and services cannot achieve? So I also included here subparts to LRE, and they define a continuum of alternative placements, what a placement is. This also extends to non-academic settings. Teachers, special education teachers, and all the team members involved in IEPs need to also be considering the non-academic settings. And then some work has been done with children in private institutions and what that looks like. Technical assistance and training activities that these education agencies, state education agencies, are required to train their teachers to be responsible for these things, so that they are knowledgeable about it. And then SEAs are required to review any evidence brought to them and investigate whether or not the local education agencies are not following the provisions. And it goes a step further and requires them to assist LEAs in planning and implementing any corrective actions. So that is what we started with, what least restrictive environment is in IDEA. And the language to me is pretty simple and pretty straightforward. But then when you get into certain situations, it starts to get a little hairy. and what is reasonable for LEAs and SEAs to do in response to the question of least restrictive environment. There's been, several cases involving it. So the first one is the Board of Education with Hendrick Hudson Central School District versus Amy Rowley. So here are kind of some of the issues that we find in schools. The continuum of placement. Education should be mainstreamed, is the idea that legislature has put forward. But how do we determine that? That has kind of come into question every now and then. Public versus private institutions. How responsible are SEAs and LEAs responsible for finding private institutions to do that? And sometimes it gets kind of sticky. And then the severity and nature of disabilities. What about behavior? And we have to really focus on educational need. And that has come up in several big cases. So Amy Rowley was a deaf student in New York. And she was doing actually very well. She was a remarkably well-adjusted child, but her parents wanted her to have an interpreter, a sign language interpreter in the classroom, and provided for her. And though it would be great for her to have that in the classroom, she was doing okay without it, and she was performing just as well or better than the other students in her classes. And so when it came around from the lower courts and there was appeals, the Supreme Court acted with good faith, and they said that the school districts were acting with good faith and were compliant with FAPE and LRE, and that they only need to provide educational opportunities that adhere to the actual language found in IDEA. Contains no requirement like the one imposed by the lower courts that states maximize the potential of handicapped children. And so kind of harsh, right? But that's reasonable. You can't require states to maximize the potential of students, only give them the same opportunities that other students without disabilities get. Hartman versus the Loudoun County Board of Education. The student was in a general education classroom. A lot of the people involved on his IEP were quite qualified. It was determined that Mark was not progressing in his classes, and that he was very disruptive in the classes, and he was getting no educational value from being in the general education classroom. And so the team and the school was, really pushing for him to be in his own, hybrid model. They weren't saying only self-contained all the time, 100% of the time, but they'd come up with a really good plan to take him out for do pull-out services and have a continuum of alternative placement, and put him in some classes that were more geared towards his level for reading and writing and mathematics, and work on communication, which was something that he had very little skill in. And so the parents continued to push that he needed to just be in the general education classroom. And after a couple years of that, they found the courts found that the county's efforts on behalf of Mark were sufficient to satisfy the IDEA's mainstreaming directive, that they were doing a lot of things to try to adhere to LRE, but also giving the student the education and the instruction that he needed. The rise, the student was considered fragile, depressed IQ, fourth grade reading level, and when it came to high school, there was a great program, but it wasn't at his closest high school. And so the school, that's what they wanted to do. They felt that with his needs and his educational needs, as well as vocational needs, that this school, that the specialized school within another regular high school, was his least restrictive environment, that he would have no educational value in agenda. He would only be monitoring classes, and that he wouldn't progress. And so the courts agreed that that is the placement that was appropriate for him. And so it kind of starts a trend when you're looking at these cases of, yes, we want to place students in the least restrictive environment. Yes, we want students to be with their non-disabled peers. We want them to learn as much as they can in that environment. But when the educational need is higher, and it can be more appropriate to put them in a continuum of alternative places. And then this is the GNETS program. This was back in the late 80s. The Georgia Network for Educational and Therapeutic Support was created, and it was thought to be a really great idea in the state of Georgia, that kids with behavior-related disabilities were removed from the general education classroom from their own schools, and they were placed in these specialized schools. Well, the thing is that these schools were mainly online, did not have both a general education and a special education teacher on site, was not providing accommodations to these students, and these kids had IEPs, but what they were getting from the GNETS program was not a free and appropriate education that's in line with their non-disabled peers. I mean, they need to be needs to be with their non-disabled peers, the same as theirs, the same educational opportunity, and they weren't getting that. And so the letter goes on to give some guidance on how to disassemble that program and what really the specific issues were. But we conclude that the state's administration of the GNETS program violates Title II. The state administers the GNETS program in a manner that results in students with disabilities being unnecessarily segregated from their peers. And so really the idea is that students need to be in the same classrooms as their neighborhood kids. And then this is a memo that went out in '94, and it talks about, it's a question and answer memo that comes from the Office of Special Education and Rehabilitative Services from the United States Department of Education. And it just goes on to say that these are the factors, they detail factors that should be considered into one continuum of alternative placement. The educational benefits available to the disabled student in a traditional classroom supplemented with appropriate aids and services in comparison to educational benefits to the disabled student from special education classroom. The same for non-academic benefits, and the degree of disruption of the education of other students resulting in the inability to meet unique needs of the disabled student. And so looking at, several different things that go into making placement decisions. However, school districts may not make decisions of placement based on just the category of the disability, severity of the disability, what you have configured as a delivery system in your school, the availability of things. They need to work to, it's required, and the availability of space or administrative convenience. So it's kind of like a warning. These are not things that this is not how we make placement decisions for students. So those are the cases, and the things that are that have come up since IDEA came out and least restrictive environment was coined. And these are kind of some of the opinions of the courts as time has gone on. So we have problems with placement. We saw that, sometimes there's an issue of availability of space or availability. A student is disruptive, but how do we know, how do we know that they're getting educational value? How do we know that their disruption is warrants them to be put in alternative placement? How do we know if the SEAs are doing all that they can to get the training for the teachers. And so you are charged with as a special education teacher, you are charged with creating an IEP and adhering to a code of ethics that encompasses a mindset of least restrictive environment, acknowledging the continuum of placement and supplementary aids and services. So to me, it's pretty straightforward. You educate, right? You're, as an educator, you teach students, but you also need to be educated on what you're doing. And as a special education teacher, considering the least restrictive environment, you need to have data, you need to have information, you need to have references. And so the next page is all the resources that are available to teachers so that they're considering all aspects of student academic life as well as non-academic life, that removes those barriers, and so they can grow alongside their non-disabled peers. So some of the resources include identifying service providers, checklists for parents and IEPs, checklists for school personnel, with the mainstreaming initiative built into it, supplemental aids and services toolkit, a consultation thought map, and progress monitoring tracking sheet. So I'll gotta go a little bit more in depth when we look at each resource. So this is a Google form that I created. I would love to give them to my parents now that I have created it. I adapted it from the Families Together Incorporated, and it's a special education family site, and it talks a lot about the things that you should be asking in IEPs as a parent. And I just thought that that was a really good resource for teachers, not only just parents, but also teachers, so they know what kinds of questions parents should be asking. And so without going into the full thing, it's just a checklist of all the least restrictive environment. Do the teachers share the same lounge? Is there physical integration? Is your special education classes in the same hall as gen ed classes? Are they in the same school that they would if they didn't have a disability? And the list just goes on, and I just find that to be a really good resource. Here's a handout to maybe help special education teachers and team members kind of see related service personnel in a different light. Related service personnel are an integral part of least restrictive environment, because what you're trying to do is you're trying to give them services. It's not, special education is not a place, it's a service, it's in the classroom. And so it's not just the special education teacher that should be providing those. Sometimes students need other providers. And so I wanted to give a resource that basically encompasses, that they participate in the general education classroom curriculum with their peers, but they're continuing to meet their annual educational goals. And it also encompasses that non-academic settings part of LRE, where they can take part in extracurricular and non-academic activities. So these services allow students to participate in a much broader sense. So here is, I really liked this little graphic, this pie chart of like who is involved typically with some of the services that are provided in schools. And so there's that. I just touched on behavior. So let's say that you have a student that has lots of behaviors that are disruptive to other students. Well, before we go down the rabbit hole of finding a continuum of placement, we have to do what we can to provide interventions. And then that data will help us make a better decision on whether or not the student needs to be placed down at another level in the continuum. And so this is an intervention. This is one aspect of LRE. Trying to have a behavior plan is pretty much LRE. That's why we do it, because we're not trying to just take a student out because they're causing problems. We want to address the target behavior and allow them to be in the gen ed classroom as much as possible. Here's another, I'm going to hammer the supplementary aids and services, and then these are potential consultation partners, and I just really have kind of put that first, and I find that to be the biggest part of LRE, is that when you have all of these different members working to help the student, there allows them to be in the least restrictive environment. I don't really know how else to say that. I like this one because it really just lists them all out, and you can like, you don't have to think too hard about it. And it's also great because you can rank order them, because some things, you know, like a student with behavior related disabilities may have a very good reading level. And so you may not need, um, you know, the reading specialist at your school. And so you can, you know, put them at a lower rank. Um, this next resource, the Circles of Support worksheet, I think that's really good as a thought map. And so when you're thinking in your IEP meetings, you guys can, you know, collaborate and work together to really think about outside of the box of who can be a part of the student's academic and non-academic life, so that they can excel and continue to stay in the least restrictive environment. And then we talked about, you know, data for behavior, you know, what have we tried, how many times have we tried it? The same thing goes for any other type of progress monitoring. And so this is more a resource for academic scores, like let's say reading or math, fluency, those kinds of things. And so, you know, we use this information so the student stays in the general education classroom setting, and we continue to progress monitor, and we see that the student is not responding to tier 2 and is not responding to tier 3. That may be when we need to say as a team that this student needs an alternative pull-out class, or something like that. So it can work for behavior as well as academic goals. This one I liked because it really came from a legal perspective. The language is really, consistent with the requirements of IDEA. The language is pretty much the same. And so this is good for staff members, school personnel, to use and to really consider when they're looking at special education as a whole on the school site. And then this one's really cool resource that I found. It's from Pennsylvania. It's about supplementary aids and services. It's a toolkit is how they developed it. And so it gives examples of a team developed, something that's developed by a team, and the types of strategies that could be implemented, and some questions that you can consider as an IEP team. And kind of answer some questions that you may have, different framework. Just a pretty neat. They even have their own court case, you know, on here to kind of bolster their position. Pretty cool little thing. So, and then I have my references on my last page. And so special education is not just a place in a school, it is a service that is being provided to students that are struggling with whatever their category of disability is. And because each student is an individual, disabled or not, they need to have special education students need to have the individualized approach. But when we use more team members and really think about the supplementary aids and services, and make it that the emphasis, we are sure to be in the least restrictive environment, because when all those measures have failed, then we know that we need to move on to the continuum of placement. And so that's kind of the position that I've come from with this policy training manual, is that what are we doing to make sure that when we when we change placement to an alternative setting, how do we know that that's going to be the best decision for the student? And the only way that we can know that is with data, and with a lot of team members kind of echoing the same thing. That is what has been found in a lot of these court cases, that the parents continue to fight for the student to be inside of the general education classroom, but consistently it was shown that the schools and the expert teachers that were very knowledgeable about the student's situation and educational needs were exhausting all of those gen ed placement supplementary aids and services, and that this is still that changing the placement may be what's best. And it was consistent. As long as the schools continue to try to do that part of the clause, um, they're going to be golden when it comes to court cases. And so data using your service providers, that's really where I think it's at. Thank you so much for listening to me talk to you about least restrictive environment, and I hope you have a wonderful day and enjoy your summer. Thank you.